Hi everyone, thank you for joining me for this presentation for Psych 546, Advanced Forensic Psychology. For this module, I will be talking about competency to plead guilty. To start us off, please check out this video about Mitchell Blair, a mother who is accused of murdering 2 of her children. Pay close attention to the interview with Dr. Shiner when he discusses what competency is. We will be diving deeper into this topic throughout this presentation. In the video we just saw, Dr. Shiner talked about what it means to be competent. It means the defendant understands the charges, they know what the judge does, they know why the jury is there, what the punishment will be, and how to help their attorney give them the best defense. Competency to plead guilty goes a little bit deeper than competency to stand trial. According to our text, Melton et al., 2017, a guilty plea must meet 3 criteria. It must be knowing, it must be intelligent, and it must be voluntary for the court to accept it. Let's take a look at our first criteria. A plea must be knowing. A judge will determine if a plea is knowing during the arraignment. A knowing plea touches on competency issues that we saw in the previous slide. It means that the defendant understands the nature of the charge, understands the penalties associated with the charge, understands the rights waived by a guilty plea. Now that's different than competency to stand trial. That means that the defendant understands they are waiving their right to remain silent, to confront one's accusers, to a jury trial, and to have counsel during that trial. The differences in competency among various stages of a case pose an interesting constitutional question that has been the source of great debate in the legal world. So think about this. Does a defendant who pleads guilty have to be more competent than one who chooses to stand trial? 2 historical cases have been analyzed in an attempt to answer this very question. Take a look at the next slide. These 2 cases created a little bit of a debate regarding the variance of competency. In the 1973 case of Sealing versus Eyman, Gilbert Sealing was charged with many crimes and initially pled not guilty, but he later wanted to change his plea to guilty before the trial began. The court accepted a plea and sentenced him for 3 counts of assault with a deadly weapon. Sealing later approached the court and petitioned for a writ of habeas corpus, claiming that he was incompetent to make a guilty plea. The court disagreed with him and found that a defendant must exhibit higher competence than required to stand trial in order to plead guilty. There's a little bit more that goes into that. They also found that a defendant must be able to make reasonable decisions about serious issues, and a defendant is only incompetent if they have a mental illness that affects those decision-making skills. Alternatively, in the Godinez versus Moran case, much of the same thing happened. Moran pled guilty, he was sentenced to death, and then he wanted to backtrack and claim that he was incompetent to make the plea. The court in that case found that defendants must exhibit the same amount of competence in both areas to stand trial and plead guilty. They also found that a defendant is able to make many serious decisions during the course of the trial, and that's why the competence is fluid between both stages. They also found that mental illness does not necessarily contribute to competence, but it definitely can. Prior to the disagreement surrounding these 2 cases, the defendants had 2 options. They were either competent or not. The disagreement created a 3rd category of semi-competent that are not protected from prosecution, which is the jury trial. This led to an issue of a defendant being found competent in some areas but incompetent in others. So what does this mean for assessments? What criteria are used to determine this? You may remember the answer from our text. If you guessed the McCatka, you were correct. In order to determine if a defendant is competent to plead guilty, professionals may use the McCatka assessment. Here they will explore if the reasons for the guilty plea are rational or irrational and analyze a defendant's decision-making abilities. This also poses the question of should the court care if the decision is rational or irrational? Often, as shown in the Moran case, it doesn't necessarily care if the decision is rational or irrational. During the course of these arguments, another question was raised regarding competency to plead guilty. Should an attorney have to agree with their client's guilty plea for it to be accepted by the court? Bonnie believes that courts do not need to understand the reasoning behind the plea if the attorney agrees. If the client and the attorney disagree, the court should discover why the defendant wants to plead guilty and only accept it if there is a well-reasoned choice behind it. Alternatively, Slobogan and Mashburn believe that the defendant must provide a well-reasoned base for the guilty plea. They work under the assumption that if the attorney and client agree on a guilty plea, the court should only accept it if the client understands the process and gives rational reasons for the plea. If both of these criteria are met, the plea should be accepted regardless of the attorney's opinion or if the defendant is well-reasoned in their choice. Let's move on to our third criteria of a guilty plea, voluntariness. How do we determine if a plea is voluntary? Is voluntariness different from coercion and/or lack of a better option? Let's compare two more court cases to see what the courts have to say about it. The case of Bordenkircher versus Hayes posed an interesting question in regards to voluntariness. In the case, the prosecutor offered Hayes two options: either plead guilty and receive a 5-year sentence, or plead not guilty and be labeled a habitual offender and receive a life sentence. Were these options constitutional in regards to voluntariness? The court thought so, because Hayes was free to either accept or decline the offer. Another example is Brady versus United States, when Brady changed his plea to avoid the possibility of the death penalty if he went to trial and was found guilty. The court ruled that his plea was constitutional because his fear did not coerce the plea, but rather caused it. Questions have been raised as to the constitutionality and ethical characteristics of these scenarios. The courts found them to be constitutional, but did not touch on whether these scenarios were ethical. In the first case, would it be classified as a manipulation or a negotiation? How might that affect voluntariness? In the Brady case, if the defendant is threatened with a worse outcome, such as the death penalty, is the plea still voluntary or could it be coercion? If you're interested to know more about the Brady case, feel free to watch this short video. This brings us to the end of our time discussing competency to plead guilty. As you have hopefully learned, there's a lot of constitutional, ethical, and philosophical debate around the characteristics of a defendant who is competent to plead guilty. Our discussion question is, should competence be determined independently of various court steps, such as competence to stand trial, search and seizure, remain silent, etc. A bonus question: does coercion/manipulation of voluntariness in regard to plea deals create an ethical dilemma within the court systems? How might this affect the work of a forensic psychologist? I can't wait to see what you guys have to say. Thanks so much for listening. We'll see you soon.